Hello and welcome to Rao's IAS 2021 edition of Prelims Test Series discussion videos based on Rao's Prelims Test Series, specifically curated to prepare aspirants for Prelims 2021. We all know that upcoming Prelims examination of 2021 is to be conducted on 27th of June 2021. It is time, whether you are a beginner or an expert, to start taking practice tests. Now, a lot of people ask why taking tests and why practicing is so important. First and foremost, it helps you in revision of the whole syllabus. Second, it helps you identify important topics from ocean of topics. Then, it lets you keep track of your own preparation and identify the lapses and weak areas. Then it enables you to evolve the right kind of strategy best suited for yourself, whether you are a high attempter or you are a person who keeps yourself limited within 75 questions. Then, through test series, you can assess the competition before the actual prelims examination and then accordingly tweak your preparation. And then finally, it helps you develop tips and tricks which are actually very useful. And all this enables you to hold your nerves, to keep calm and maximize your score in the actual examination. So Rao's IAS test series is a set of 55 tests which caters to both static as well as dynamic needs of prelims examination. It initiates you into testing through topic tests to help you prepare a subject in a piece-by-piece manner, and then followed by thematic tests which then summarizes the complete subject. Along with this, simultaneous focus-based current affair tests are conducted on a monthly basis. And then finally, just before the prelims examination, there will be full-length tests for the fine-tuning of test-taking strategy. So finally, moving to this series. The objective of these discussion videos is to help you understand how UPSC makes questions, thereby empowering you to clear prelims examination. So these discussions will follow the following pattern. We will pick up a previous year question and then gain the conceptual clarity required to solve it. Then we will take questions from Rao's Prelims Test Series which were designed to emulate the same PYQ and will try and solve it. In this process, we will also learn few tips and tricks which can help you enhance your strike rate. So in this manner, each video will give you an insight into 20 topics. So in this video, we will pick up 10 MCQs from Rao's two of the topic tests on polity, constitution and governance, that is polity topic 3, 4 along with thematic test. Let us now begin the discussion. We will begin the discussion with two questions taken from the executive section of the Constitution of India. We know that executive of India includes president, governor, council of ministers and many others. And so, one of the questions which we have taken from the past year question was asked in 2013. Which one of the following statements is correct? And we have chosen this question because through this question you will get to revise many provisions related to executive at the state level. So statement A says, in India the same person cannot be appointed as governor for two or more states at the same time. Statement B says the judges of High Court of the states in India are appointed by the governor of the state, just as the judges of Supreme Court are appointed by the president. Statement C says no procedure has been laid down in the Constitution of India for the removal of governor from his or her post. And finally, statement D says in the case of union territory having a legislative setup, the chief minister is appointed by the lieutenant governor on the basis of majority support. So now you can easily see that how these four statements are going to test your knowledge of Constitution of India with respect to the relationship of governor with many states, with judiciary, with respect to his or her removal and with the Council of Ministers, especially in case of union territories. And so, for solving this particular question, we are going to take the help directly from the Constitution because all these provisions are already given in the Constitution. Starting with statement A, which says that the same person cannot be appointed as governor for two or more states at the same time. And this is not true because Article 153 says that same person can be appointed as governor of two or more states. Now at Rouse IAS, we recommend students to just not keep yourself limited to standard textbooks. But whenever the reference is made, you should go and check the original constitution because that is where the questions are framed from. So when you look at Article 153, titled as Governors of States, which says that there shall be a governor for each state. But if you focus on the line beneath that, it says, provided that nothing in this article shall prevent the appointment of the same person as governor for 2 or more states. So the constitution itself does not limit the number of states where a single person can be appointed as governor, and hence clearly the statement A is wrong. Similarly, let's consider B statement, which says that judges of High Court are appointed by the governor. And it tries to confuse you because you know that judges of Supreme Court are appointed by the president. And if you have not done careful reading of standard textbooks or the constitution, you would think that an analogy can be drawn between Supreme Court and High Court, but this is also incorrect because Article 217 or Article 217 says every judge of a High Court shall be appointed by the President. So here is the original constitution with Article 217 titled as Appointment and Conditions of the Office of Judge of a High Court. It says, or rather it starts by saying, every judge of a High Court shall be appointed by the President by warrant under his hand and seal. Of course, whatever has been written henceforth has been annulled by the Supreme Court, but that is a matter of another discussion. So clearly, statement B is also incorrect, and that leaves us with only C and D. And let's leave C for a time period. And let's focus our attention towards statement D. In the case of a union territory having a legislative setup, the chief minister is appointed by lieutenant governor on the basis of majority support. Now, we know that provisions related to union territories have been given separately from the states. So the provisions dealing with union territories are dealt within the Constitution of India in Part 8. And the provisions dealing with all those union territories having a legislative setup are dealt within Article 239AA. And so let's look at the provision. So Article 239AA lays down special provisions with respect to Delhi, which is of course a union territory having a legislative assembly along with Council of Ministers. And if you scroll down to the 5th clause, and it says the chief minister shall be appointed by the president and other ministers shall be appointed by the president on the advice of chief minister. So it is a very important thing to remember that in case of union territories having a legislative setup, the chief minister is not appointed by lieutenant governor but rather appointed by the president, and so statement D is also incorrect. And so of course that leaves us with C statement. No procedure has been laid down in the Constitution of India for the removal of governor from his or her post. And this is quite different from the case with the president because there is a detailed procedure laid down for the removal of the president known as impeachment. And so the right answer was C. And so keeping in mind such a wide question, we have formulated another question dealing with the discretionary powers of the governor, which are extremely wide if you compare the discretionary power of the governor with that of president. And so that is why it is important to have a clear-cut understanding as to discretionary powers of governors in India. And so the question, which of the following falls or fall under the discretionary powers of the governor? Statement 1. The appointment of the chief minister when neither a single party nor a combination of parties emerges from the election with a clear majority. Statement 2. With regard to making a report to the president under Article 352. Statement 3. The reservation of bills for the consideration of the president. And so, in this respect, let us just quickly go over to the discretionary powers of the governor given in our constitution. And so the governor has 3 distinct discretionary powers in the following cases. When it comes to the appointment of chief minister, we know that chief minister is appointed by the governor. But what happens when there is a hung assembly, when neither a single party nor an alliance of parties clearly emerges from the election with a clear majority? And in those cases, the governor does not act on aid and advice of Council of Ministers, but rather she acts on her own discretion. And so clearly statement 1 is correct. Let's just now see statement 2. with regard to making a report to the President under Article 352. To understand the veracity of this particular statement, you need to be very clear about the provisions related to emergencies in the Constitution of India. Because if you don't know that, you would easily mark it as correct. Because you know that for imposition of President's rule, there has to be a report sent to the President by the Governor about her satisfaction that a situation has arisen in which the government of a state cannot be carried on in accordance with the provision of the Constitution. But that provision has been given in Article 356 and not in Article 352. And so that is why it is very important to keep in mind provisions along with the articles themselves. And the third discretionary power of the governor comes from the power of the governor to reserve the bill for consideration of President of India. And on those matters, governors can decide on their own without the advice of Council of Ministers. And so, statement 3 is correct, leading us to the right answer B, 1 and 3 only. And from this question, an important takeaway is that usually the governor of a state has to act on aid and advice of Council of Ministers. But there are 3 situations in which the governor can act independently of the Council of Ministers, that is, appointment of a chief minister when there is a hung assembly, then recommending imposition of President rule, and finally reservation of bills for the consideration of President. So moving on to the second question dealing with the executive. We'll see the question from our PTS later on, but before that, let us first consider the question which was asked in 2013. Consider the following statements. The Council of Ministers in the Centre shall be collectively responsible to the Parliament is statement 1. Second statement is the Union Ministers shall hold the office during the pleasure of the President. Third statement is the Prime Minister shall communicate to the President about the proposals for legislation. And all these mechanisms are guided by our Constitution. So we cannot but have a look at original provisions of the Constitution, specifically Article 75 and 78. So if you look at clause 2 of Article 75, it says that the ministers shall hold office during the pleasure of the President. And so, second statement is correct. Similarly, if you look at the third subclause of Article 75, it says, Council of Ministers shall be collectively responsible to the House of the People, that is Lok Sabha, and not to the Parliament. We know that Parliament in India consists of 3 parts. First is President, then is Lok Sabha, and then finally is Rajya Sabha. But the original provisions of the Constitution provide for the accountability of the Council of Ministers to the House of the People and not to the Parliament. And so, statement 1 is incorrect. Similarly, third statement, which deals with the communication of the information to the President by the Prime Minister, is also correct, and that is verbatim provided in Article 78, which deals with the duties of Prime Minister with respect to furnishing of information to the President. If you read Article 78, it says that it shall be the duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to administration of the affairs of the Union and proposals for legislation. And so you can see that the right answer is B, 2 and 3 only. But there is another way to solve this particular question. If you just remember that the Council of Ministers in the Centre is responsible to Lok Sabha and not to the Parliament, you know that statement 1 will be incorrect. And if 1 is incorrect, so is option A, option C and option D, leaving us with only one choice. And so that is another way to solve this particular question. And so realizing the importance of these articles, dealing with the important provisions of the central government, we have formulated this question in our prelims test series. Consider the following statements. The President of India is a part of Parliament of India. The Constitution of India vests the executive power of the Union formally in the President. The President can be removed from the office only by the Parliament by following the procedure for impeachment. And so for solving this particular question, we will need information scattered across 3 different articles. Article 79, Article 53 and Article 61. Let us start with Article 79, which is the first article dealing with the Parliament, and it constitutes the Parliament. Says, there shall be a Parliament for the Union which shall consist of the President and two houses to be known respectively as Council of States and House of the People. So there are two important takeaways from Article 79. First is that Parliament consists of President, House of the People and Council of the States. And second is that these names that we used for our houses are not given in the Constitution. Instead, Constitution calls them House of the People and Council of States. And so, first statement is correct. Then let us now look at Article 53, which talks about executive power of the Union. And it says, the executive power of the Union shall be vested in President and shall be exercised by him either directly or through officers subordinate to him in accordance with this Constitution. And so, it is true that the Constitution of India has vested formally the executive power of the Union in the President. And then finally, as we know, that there is a formal procedure for impeachment of the President given in Article 61. And that procedure has to be followed when a President is to be removed. And so, third statement is also correct, leading us to the right answer D, 1, 2 and 3. Okay, so now we will take up questions related to legislature or parliament. And the question which we have chosen from previous year is a very important one, and it deals with the provisions of the money bill. The question is, regarding money bill, which of the following statements is not correct? And so this question also highlights the need to read the question carefully. You have to find out which of the following statements are not correct. Now, as we all know that provisions of money bill are given in Article 110 of the Constitution, and we'll look at them. But let us first understand why this question was asked in 2018. And that was because a lot of bills were passed by the central government where the nature of the bill was categorized as money bill. But opposition parties, along with various constitutional thinkers, questioned the categorization of those bills as money bills. And this controversy raged mainly over Aadhaar bill being categorized as money bill. Now, since the ruling party did not have majority in Rajya Sabha, the categorization of bills as money bills enabled the government to bypass Rajya Sabha. And so that is why they adopted this route, and that is why this was in news, and so this question came. And so before going into the statements, let us first look at the actual constitutional provisions with respect to the money bill. So as you can see, Article 110 defines money bill. So a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters. What are those matters? And there are 6 such matters enlisted in the Constitution under Article 110. So if a bill contains only these provisions or any combination of these provisions, only then that bill will be a money bill. But if a bill contains these provisions along with any other provision, that would not be money bill as written in the Constitution. So what are those conditions? Imposition, abolition, remission, alteration or regulation of any tax, regulation of the borrowing of the money or the giving of any guarantee by the Government of India, the custody of Consolidated Fund of India or the Contingency Fund of India, the appropriation of money out of Consolidated Fund of India, declaration of any expenditure charged on the Consolidated Fund of India, receipt of money on account of Consolidated Fund of India or public account of India, or the custody or issue of such money, and any matter incidental to any of the matters specified above. And so now let's have a look at the statements. It says, a bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. As you can see, the imposition, abolition, remission, alteration or regulation of tax is given in the list of items. If included, can lead to categorization of the bill as money bill. So this is correct. Then statement B is, a money bill has provisions for the custody of the Consolidated Fund of India or the Contingency Fund of India. And you can see third condition is itself the custody of the Consolidated Fund of India or the Contingency Fund of India. So this is also correct. Now let us know in the comment section which authority has the custody of Consolidated Fund of India and Contingency Fund of India.
Now, statement C is a money bill is concerned with appropriation of monies out of contingency fund of India. Now, as far as the provisions of contingency fund of India is concerned, the conditions only deal with the custody and not with the appropriation of money. As far as appropriation or taking out of money is concerned, that is only from consolidated fund of India. So to take out money from contingency fund of India, you don't need to pass a bill. But if you want to take out money from consolidated fund of India, you definitely need a bill, and that will be money bill. And so statement C is incorrect. Statement D, of course, is correct because the regulation of borrowing of money or giving of any guarantee by the government of India needs money bill, and that is correct. So the right answer was C because the question asked which of the following is not correct, and C is not correct, leading us to the right answer C. So keeping in mind the importance of money bill, we have formulated this question in our prelims test series. Consider the following statements about the money bill. Statement 1. There cannot be any judicial review of the Speaker's decision to qualify a bill as a money bill. A money bill can only be introduced in the Lok Sabha. Joint sitting cannot be called for passing of the money bill. And President cannot return a money bill for the reconsideration of the House. So through previous year question, we covered the conditions for the bill to be categorized as money bill. And now in the prelims test series question, we will test our knowledge with respect to the process involved in the passage of the money bill. So first and foremost, a money bill can only be introduced in Lok Sabha. And if any question arises whether a bill is a money bill or not, the decision of the Speaker thereon is final. You should also know that the Speaker is under no obligation to consult anyone in coming to a decision or in giving certificate that a bill is a money bill. So, of course, the statement 2 is correct. You should also know that provisions of Article 108 regarding joint sitting of both houses do not apply to money bill, and hence joint sitting cannot be called for passage of money bill. So, statement 3 is also correct. Since the money bill is introduced in Lok Sabha, after approval from President cannot return a money bill for the reconsideration of the Houses. And so statement 4 is also correct. We are left with statement 1, whether it is true or false. Now the Constitution says that the categorization or certification of a bill as a money bill cannot be challenged or cannot be questioned upon. But in Aadhaar case, Supreme Court ruled that judicial review is a basic feature of the Constitution, and Supreme Court observed that Speaker's decision to qualify a bill as a money bill is open to judicial review. And so, statement 1 is incorrect because it simply says there cannot be any judicial review of certification of a bill as a money bill. And so that leads us to the right answer C, that is 2, 3 and 4. Now under the parliamentary setup, the functioning of parliamentary committees are very, very important, and there are many parliamentary committees. And if you read any standard textbook, you will get to know a lot about them. And so in 2013, UPSC asked, consider the following statements about Parliamentary Committee on Public Accounts. Statement 1, it consists of not more than 25 members of Lok Sabha, which is obviously incorrect because it consists of only 22 members, 15 from Lok Sabha and rest 7 from Rajya Sabha. Statement 2 is correct because it scrutinizes appropriation and finance accounts of the government and it examines the report of the CAG of India. And so the right answer was 2 and 3. Not just that, in 2014, UPSC asked another question on committees, which one of the following is the largest committee of the parliament? And the answer would be committees on estimates. And let us know in the comment section how many members does this particular committee has. And so, realizing the importance of the committees, we make sure that we ask questions on committees. And so, in our prelims test series, we have formulated this question. Which of the following statements are correct about estimates committee? Statement 1, all the members of this committee are from Lok Sabha only. Statement 2, it examines the budget estimates before they are voted upon by the parliament. Now, we know that estimates committee is a type of financial committee. And it is one of the parliamentary committees which is permanent in nature, or that is a standing committee. And the purpose of this committee is to examine estimates included in the budget presented in the parliament. Apart from that, it also suggests economies in public expenditure. It has 30 members and all of them are from Lok Sabha only. And so, statement 1 is correct. All the members of this committee are from Lok Sabha only. So, it is important to remember that Rajya Sabha has no representation in this committee. These members are elected by the Lok Sabha every year from amongst its own members according to the principles of proportional representation by means of single transferable vote. Thus, all the parties get their due representation in this particular committee. Of course, the term of office is 1 year. An important aspect to remember is that a minister cannot be elected as its member. We have already seen it examines the budget estimates only after they have been voted by the parliament and not before that. And so, the second statement, it examines the budget estimates before they are voted upon by the parliament, is incorrect, which leads us to the right answer A, 1 only. And so, its recommendations are advisory in nature but not binding on the respective ministries. So, when you are preparing parliament, keep in mind that the committees and comparison their functions, their memberships are very important from the perspective of prelims examination. So let us now transition from parliament to judiciary. And first we will discuss two previous year questions back to back, and then we will look into two PTS questions. So in 2012, UPSC had asked which of the following are included in original jurisdiction of the Supreme Court. A. Dispute between the Government of India and one or more states. A dispute regarding elections to either house of the parliament or that of legislature of a state. A dispute between Government of India and a union territory. And a dispute between two or more states. Similarly, in 2014, UPSC asked the power of the Supreme Court of India to decide disputes between the centre and the states fall under its advisory jurisdiction, appellate jurisdiction, original jurisdiction, or writ jurisdiction. So now you can see that jurisdiction of higher courts, that is Supreme Courts and High Courts, are very important. And so in this regard, let us try and solve these questions first. And for that, we will have to first understand the original jurisdiction of Supreme Court. Now, original jurisdiction implies the power of a court to hear a case for the first time, as opposed to appellate jurisdiction. So, if a court has original jurisdiction in certain matters, then that will mean that in those matters, aggrieved party can directly approach that court. So for example, any dispute between Indian government and one of the more states, any of the states can directly walk into Supreme Court without having to first file the case in High Court. Similarly, any dispute between Indian government and one or more states on one side and one or more states on the other side, or any dispute between two or more states, so any case dealing with the federal structure, that is involving center and state, either of the aggrieved party can directly walk into the Supreme Court. Similarly, under the matters of Article 32, that is the matters dealing with the enforcement of the fundamental rights, the aggrieved party can directly walk into Supreme Court without having to go first to the High Court. And hence, Supreme Court can issue writs, directions or orders, including writs in the nature of mandamus, habeas corpus, quo warranto, prohibition and certiorari. Also, Supreme Court has power to direct the transfer of a criminal or a civil case from High Court in one state to High Court in another state. And now let us see the options. It says a dispute between Government of India and one or more states. Of course, that is original jurisdiction. Then a dispute regarding elections to either house of the parliament or that of a legislature of a state. Now this is not the original jurisdiction of a Supreme Court because you first have to approach a High Court. Once the judgment has been given by the High Court, then a challenge can be drawn in Supreme Court. Similarly, statement 4 is also correct. A dispute between two or more states involves. Similarly, statement 4 is also correct, as a dispute between two or more states can be directly taken to the Supreme Court. Whereas if you read statement 3, it is incorrect, because if you read Article 131, which deals with the original jurisdiction of the Supreme Court, it nowhere mentions a dispute between Union Territory and the central government. Similarly, this question asked in 2014, the power of the Supreme Court of India to decide dispute between centre and the state falls under its original jurisdiction. So now you can see that jurisdiction of Supreme Court is very important. And so, we have formulated this question in prelims test series dealing with writ jurisdiction of Supreme Court. Which of the following statements are correct? Habeas corpus is a writ issued by the court to bring before the court a person from illegal custody. Statement 2 is, by using the writ of mandamus, the court may order the public officials to perform their legal duties. Statement 3 is, by the writ of quo warranto, the court may strike off an order passed by any official of the government, local body or a statutory body. And certiorari is a writ issued to a person who authorized to occupy a public office to step down from that office. And so in this regard, let us now first understand the meaning of these words given in Article 32 of our Constitution. Starting with habeas corpus, which is a writ issued by the court to bring before the court a person from illegal custody, and so statement 1 is correct. The court can decide the legality of detention and release the person if detention is found to be illegal. And if you are reading newspaper, you must have gone through a lot of habeas corpus petitions filed in Supreme Court with respect to a lot of activists being arrested across the country by the state governments. Then, by using the writ of mandamus, the court may order the public official to perform their legal duties, and so statement 2 is also correct. Then prohibition is a writ to prevent a court or a tribunal from doing something in excess of its authority. So that is like to prevent a travesty of justice. If Supreme Court comes to know about an order which is to be passed and it thinks that that particular court does not have jurisdiction to pass that order, Supreme Court can prohibit that court or tribunal from issuing that judgment. By the writ of certiorari, the court may strike off an order passed by any official of the government, local body or a statutory body. And so you can see that the fourth statement is incorrect because it says certiorari is a writ issued to a person who is authorized to occupy a public office to step down from that office, which is actually quo warranto, which means that third statement is also incorrect. And so you can see that the definition of certiorari and quo warranto have been exchanged with each other in order to test your exact information about these terms. And so the right answer was A, 1 and 2 only. And it is very important to keep in mind the definition and understanding of these 5 important writs given in Article 32 of our Constitution. Similarly, with respect to the original jurisdiction of the Supreme Court, we have formulated this particular question in our prelims test series. Which of the following statements are correct? And this particular question deals with the jurisdiction of High Court. The original jurisdiction of a High Court includes the enforcement of fundamental rights, the settlement of the disputes relating to election to the union and state legislatures, and the jurisdiction over the revenue matters. Statement 2. Its appellate jurisdiction extends to both civil and the criminal matters. Statement 3. In civil matters, the High Court is second appeal court only. And so in this regard, let us just try and understand the jurisdiction of High Court first. If we talk about original jurisdiction of a High Court, the matters in which you can directly approach High Court without first having to go through the district courts, and that is enforcement of fundamental rights, settlement of disputes relating to the election to the union and the state legislatures, and the jurisdiction over revenue matters. So in all these 3 matters, people can directly approach High Court, and that is why statement 1 is correct. If we talk about appellate jurisdiction of High Court, appellate jurisdiction meaning that you cannot directly approach High Court in those matters, and it extends both in civil as well as criminal matters. And so that is why statement 2 is also correct. Whereas statement 3 is incorrect because in the civil matters, the High Court is either a first or a second appeal court. Whereas the statement says in the civil matters, the High Court is second appeal court only. And with the addition of the word only, third statement has become incorrect, leading us to the right answer A, 1 and 2 only. So as far as the judiciary portion is covered, you can see that through previous year questions and through prelims test series, we have gone through original and appellate jurisdiction as well as writ jurisdictions. And when you prepare this topic, these are the most important aspects which you have to keep in mind. Okay, so after dealing with executive, legislature and judiciary, it's time to take up a question on center-state relation. And for that, we have taken a question which was asked in 2013. The parliament can make any law for whole or any part of India for implementing international treaties, A. with the consent of all the states, B. with the consent of the majority of the states, C. with the consent of the states concerned, or D. without the consent of any state. Now we know that the Constitution of India, although follows a federal structure, but it allows a lot of conditions in which Parliament is enabled to make laws in matters of state list, especially in matters dealing with the implementation of international treaties, and that is enabled through the provision of Article 253. And let's just see. So the provision of Article 253 says legislation for giving effect to international agreements, notwithstanding anything in foregoing provisions of this chapter, Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at an international conference, association or other body. And nowhere in this particular article has the reference been given to the permission of the states. And so, the right answer would be D, without the consent of any state. Since UPSC has already asked this question, we have designed the following question in our prelims test series dealing with center-state relation. Consider the following statements regarding the union-state relations in India. Statement 1. The Parliament may legislate on the state subjects in some special cases. Statement 2. Even without the request of two or more states, the Parliament can legislate on the state issue. Statement 3. The failure of a state to give effect to any of the directives of the Union may lead to a declaration of the constitutional breakdown in the state. We need information related to center-state legislative relationship, which is dealt within Article 249, 252 and 253. 253 we have already dealt in previous year question. So we know that in normal circumstances, Parliament can enact laws in matters of central list and concurrent list. Similarly, state legislatures can enact laws on matters of state list and concurrent list. But constitution makers thought it appropriate to enable Parliament under certain circumstances to legislate on state list as well. And one of those conditions is that if Rajya Sabha, which is Council of States, passes a resolution to that effect, Parliament can make laws in the matters of state list. Similarly, if a proclamation of emergency is in force, then Parliament is empowered to make laws in state list. Then, if two or more states pass a resolution, so that is like surrendering a state list to the central government, and then finally, as we have seen, for enforcing international agreements. So these are the four conditions under which Parliament is empowered to legislate in matters dealing with state list. So statement 1 is correct, as the Parliament may legislate on the state subjects in some special cases. Statement 2 is also correct, because even without the request of two or more states, the Parliament can legislate on state issues, for example, for enforcing international agreements, in case of proclamation of emergency, or if Rajya Sabha or Council of States passes a resolution to that effect. And so second statement is also correct. Now third statement, which deals with the directive of the Union towards states, and that has been dealt with in Article 365, effect of failure to comply with or to give effect to directions given by the Union. Where any state has failed to comply with or to give effect to any directions given in the exercise of the executive power of the Union under any provisions of this Constitution, it shall be lawful for the President to hold that a situation has arisen in which the government of state cannot be carried on in accordance with the provision of this Constitution. And so, this is also correct. Now we know that what happens when there is a constitutional breakdown in a particular state. Of course, that means imposition of precedent rule. And so, in this regard, all three statements are correct, leading us to the right answer, D. So after having delved into center-state relation, it's time for us to look at third tier of democracy in India, that is Panchayati Raj. And so a very detailed question was asked in 2011, and that is why we have chosen it. The Constitution 73rd Amendment Act 1992, which aims at promoting the Panchayati Raj institution in the country, provides for which of the following? First is Constitution of District Planning Committee. state election commissions to conduct all panchayat elections, establishment of state finance commission. Now, in order to arrive at the right answer, we will go and look at part 9 of the constitution, which deals with the panchayats, which of course starts with article 243 by defining various terms. Then it moves on to define Gram Sabha, constitution of panchayat. And so if you look at article 243I, it says constitution of finance commission to review financial position. Then similarly, if you look at article 243K, it talks about elections to panchayats, and within that article, it deals with the constitution of state election commissions. But throughout this list, there is no mention of district planning committee, because that is not in part 9, but rather in part 9A, which is not the 73rd constitutional amendment, but rather 74th constitutional amendment. And there, if you see article 243ZD talks about committee for district planning. And so now you can easily understand that why finer print of constitution and detailed reading is required, because only then you would know that this is not contained in 73rd, rather in 74th constitutional amendment, leaving us with the right answer 2 and 3 only, that is C. And so, to leave you with notes, Constitution of District Planning Committees was provided by 74th constitutional amendment dealing with urban local bodies, whereas state election commissions and State Finance Commission have been provided within 73rd Constitutional Amendment Act. And so in this regard, we have formulated a question on 73rd Constitutional Amendment Act. Statement 1. A three-tier system of Panchayati Raj for all states having a population. Which of the following are the features of 73rd Constitutional Amendment Act 1992? Statement 1. A three-tier system of Panchayati Raj for all states having a population of over 20 lakhs. Reservation of the seats for the scheduled caste, the scheduled tribes and the women only. To appoint State Finance Commission to make recommendations regarding the financial powers of the panchayats. And the fourth statement is to constitute District Planning Committee to prepare a draft development plan for the district as a whole. So before going into the solution to this particular question and analyzing 73rd Constitutional Amendment, one thing which should have struck your mind is that statement 4 cannot be correct. Because just in the previous year question, we understood that Constitution of District Planning Committee is a provision of 74th Constitutional Amendment and not 73rd Constitutional Amendment. And so let's see, with this information, can we arrive at the right answer? And so if fourth statement is incorrect, B cannot be correct, C cannot be correct, similarly D cannot be correct, and leaving us with the right answer A, 1 and 3 only. But nonetheless, let us now understand independently why second statement is also incorrect. So we know that 73rd Constitutional Amendment Act has constitutionally mandated a three-tier system of Panchayati Raj at village, block and district levels for states having a population of over 20 lakhs. So that is correct. But the reservation of the seats in panchayats have been provided for scheduled caste, scheduled tribes, OBCs and women. Whereas if you read the second statement, it does not mention OBCs and it says reservation of the seats for scheduled caste, scheduled tribes and the women only. So which is incorrect. Of course, we have already seen that it provides for the appointment of or the constitution of Finance Commission to make a recommendation regarding the financial power of the panchayats. So ultimately only 1 and 3 options are correct, which leads us to the right answer A. Now schedules to the Constitution of India are very, very important. Whether it is 7th schedule, 10th schedule, 3rd, 4th or 5th schedule. And so just to demonstrate the importance, we have taken a question which was asked in 2019. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? And so of course the answer is through the provisions of 5th schedule. We know that Indian Constitution provides autonomy to tribal areas in matters of governance under 5th and 6th schedule. And so, realizing the importance of 5th, 6th schedules as well as 10th schedule dealing with anti-defection law, we have formulated these two questions. First is, which one of the following are correct about 5th and 6th schedule areas? Statement 1. Unlike the provisions of the 6th schedule, the legislative and the judicial powers are denied to the 5th schedule areas. Statement 2. The tribal advisory councils established under the provision of 5th schedule are given the financial power for preparing budget for themselves. Similarly, we have also formulated another question, although we will not discuss it. Consider the following statements about anti-defection law, which are the provisions given in the 10th schedule of the Constitution to India. Statement 1. There is a fixed timeline before which the Speaker needs to decide over the disqualification of the matters. Statement 2. A member who has been disqualified under the anti-defection law can be appointed to a remunerative political post. Statement 3. The disqualification of a member under the anti-defection law bars the members for being re-elected as a member of the House. Statement 4. A member who has resigned from the House cannot be disqualified under anti-defection law. Which of the statements given above are incorrect? So coming back to the question on 5th schedule. So in order to answer this question, we need not only a clear-cut understanding of the provisions of the 5th and 6th schedule, but we also need a good comparison table between the two. So we know that under the provisions of the 5th schedule, a tribe's advisory council has been envisaged, whereas under the provisions of the 6th schedule, an autonomous district council or a regional council has been created as an institutional mechanism for the administration of their respective areas. And so if you analyze the provisions, you will see that the tribes' advisory councils have very limited powers, and those are mostly executive in nature. Whereas if you see district councils or regional councils, under the provisions of the 6th schedule, they enjoy extensive and wide powers, which extends in the domain of executive, legislative and judiciary as well. And these aspects have been specified in the Constitution of India. Now if you do the comparison of the financial powers of these two, you will see that tribes' advisory councils are not given financial power, whereas the district and regional councils have been given power to mobilize their own resources. They are authorized to levy, and not just levy but collect land revenue and taxes within their respective jurisdiction. And so, if you read the statement 1 again, unlike the provisions of the 6th schedule, the legislative and the judicial powers are denied to 5th schedule areas is correct. Whereas if you read the second statement, the tribes advisory council established under 5th schedule are given the financial power, that is incorrect. Leading us to the right answer A, 1 only. And so finally we have come to the last question. The 10th question deals with the constitutional bodies, the bodies which are created by the Constitution. And in 2013, UPSC asked a question about Attorney General of India. Consider the following statements. Attorney General of India can take part in the proceeding of the Lok Sabha, be a member of a committee of Lok Sabha, can speak in Lok Sabha, or can vote in Lok Sabha. Which of the statements given above are correct? Now we know that provisions dealing with the Attorney General of India is given in Article 76 of the Constitution of India. And when combined with other articles of the Constitution, here are the rights of Attorney General. First, in the performance of his duties, he has right of audience in all courts in the territory of India. He has the right to speak or take part in the proceeding of both the houses of the Parliament. And so, that includes Lok Sabha, and hence the statement 1 is correct, but without a right to vote. So although he or she can take part in the proceeding of both the houses of the Parliament but cannot vote, and so statement 4 is incorrect. Similarly, he has the right to speak or to take part in the meeting of any committee of the Parliament of which he is named as a member. And so he can be a member of a committee of the Lok Sabha and can also speak in Lok Sabha, as we have already discussed. And so the right answer was 1, 2 and 3. And similarly, we have formulated a lot of questions on a lot of constitutional bodies, including Election Commission, Finance Commission, but we have chosen to discuss this question deliberately because the previous year question deals with the rights of the Attorney General. Whereas if you read this question, it deals with the procedural part of Attorney General. Which of the following statements are correct about Attorney General for India? Statement 1. The President can appoint a person who is qualified to be a Supreme Court judge as the Attorney General of India. Statement 2. He has the right to audience in all the courts in India. Statement 3. He holds the office at the pleasure of the President. And in order to solve this question, let us look at Article 76. The first clause says the President shall appoint a person who is qualified to be appointed a judge of the Supreme Court to be Attorney General of India. Then third clause says in the performance of his duties, the Attorney General shall have right of audience in all courts in the territory of India. And if you read fourth clause, the Attorney General shall hold office during the pleasure of the President and shall receive such remuneration as the President may determine. All these three statements have been taken from the Constitution as it is, and so that is why the right answer is D, 1, 2 and 3.